Welcome to today's video on the DMCA. I'm Rick Chapo with DMCAagentservices.com. Today we're taking a look at frequently asked questions associated with the DMCA. These are questions that we've seen posted in forums and what have you, or questions that we've received from clients and potential clients regarding this federal law. So what is the DMCA? Well, it's the Digital Millennium Copyright Act. It's a federal law that was enacted in 1998, signed into law by President Clinton, and it addresses copyright infringement in the online environment, amongst other subjects. The law has been in existence for 20 plus years and has really sort of achieved its main objective, which was to avoid a situation where courts would grind to a halt because of a tsunami of copyright infringement lawsuits. Keep in mind, Google and sites of this sort that are large tend to get millions of DMCA complaints either a month or in a year. And so if those cases were in fact filed in the U.S. court system, if no DMCA existed, well, the court system would just be a disaster. There aren't nearly enough judges or courtrooms to deal with all of that work. So the DMCA in that sense has been successful. It does have its critics and does have its flaws. Absolutely, it is not a perfect piece of legislation by any stretch of the imagination, but it's what we've got, and so far not a lot of people have come up with anything better. And I suspect it'll be the law for online copyright for at least another couple decades. So let's get to the questions. The first question that we've been asked is, what will the DMCA agency do to enforce the law? Well, the DMCA agency isn't going to do anything because there is no agency. The DMCA is a law. It is not a federal agency. It's not like the IRS or anything of that sort. In some situations with online laws, you'll see Congress enact a law and they will authorize an agency to act on that law. So, for instance, we have the Children's Online Privacy Protection Act, and the Federal Trade Commission, or FTC, is authorized to issue rules and regulations and pursue enforcement actions against parties in relation to that legislation. With the DMCA, there is no such authorization. There is no government agency that's going to get involved. You don't have to worry about that, regardless of how you're interfacing with the DMCA. Instead, what the government did was they set up a voluntary compliance process, which is found in Section 512, and the three parties involved in the dispute, and that would be the copyright owner, the person who is posting the content in question without allegedly permission, and then the website or app where that content is being posted. And the compliance process is, as you would think, it's a procedure that the parties follow to try to resolve the dispute. And in about 99% of cases, it works. If it doesn't work, at that point, the copyright owner must decide whether they want to pursue an actual copyright infringement lawsuit against the person who posted the content. And if the decision is to do that, they would file a copyright infringement lawsuit in federal court. So that's how that resolves. So DMCA agencies wouldn't worry about it. There's no such thing. There are no enforcement actions where you're going to be hit with regulations and rules. Second question we get has to do with Section 512 and who exactly it benefits. So you're going to read articles and maybe watch videos online that will talk about how Section 512 of the DMCA gives copyright owners the power to get content taken down offline, how it's a real benefit for copyright owners. At the same time, you'll read articles and see videos that say, well, no, it's actually a real benefit for websites and internet-connected apps because it gives them immunity, total immunity from monetary damages associated with copyright infringement claims for content uploaded by users. So what does that mean? Let's talk about, for example, Facebook. Let's say I go out and I see an article in the New York Times I think is interesting. I copy it word for word and I post it on my Facebook page. Well, under the DMCA, under Section 512, I can be held liable for copyright infringement for that because I posted it. However, Facebook cannot because they were not involved in the actual posting. It was not a proactive step by them. They just happened to be the innocent website where I posted it. So that's the immunity and the obvious huge benefit that websites and internet-connected apps, small and large, get out of Section 512. So which group of articles and videos are right? And the answer is both. Remember, we're talking about a law that was set up to try to create an informal process for resolving copyright infringement disputes online without requiring court intervention. And so it's going to contain areas and sections that benefit all the parties involved, even the party that posted the content. So if you read an article and you're thinking, well, this doesn't seem very advantageous to one side or the other, and just keep in mind that there are different parts of Section 512 that are going to benefit everybody. So the articles, although they may appear in conflict, really are not. So our third area, we get this all the time. Hey, some sites don't follow the DMCA. What's the deal? And the answer is yes, some sites do not follow the DMCA. Let's start with the most obvious group. Those are websites or apps or even hosting companies that are located outside of the United States. If they do not view the United States as their target market, then why would they comply? The DMCA is a law in the United States. It's not enforceable in other countries. Other countries will have their own copyright infringement laws. Some will be similar to the DMCA and some will not. So that's a pretty obvious situation where you're going to see some sites just not comply. And having said that, now a lot of international sites or sites that are based outside of the U.S. That are targeting the U.S. are going to comply just because they don't want to run into lawsuits here and they want to make sure they have access to the market at all times. Given the huge consumer market in the U.S. and the very thriving business-to-business market, you're going to see most hosts comply, as well as websites that allow user-generated content, just because, again, it's free to comply and it's easy to do and you're getting immunity. So why wouldn't you? Excuse me. Our next section, DMCA abuse. Copyright owners are using the DMCA to throttle poor innocent posters of content. DMCA abuse is a problem. Yes, it is. Absolutely. It's one of the areas of the DMCA that really could use a revision. The reason being is that there's really no ramification or consequence for copyright owners who issued DMCA takedown notices that don't have any merit. There is a clause in the DMCA that says that those parties can be found liable for damages for doing so. However, the evidence that has to be provided is subjective, and it's subjective from the copyright owner's perspective. So all the copyright owner has to do is get up on the stand and say, well, I thought it was a valid complaint. And that's it, even if it's obvious it's not. So you rarely see parties that file takedown notices, even when they're obviously abusing the system and the complaint really doesn't have much merit. You rarely see them get into trouble for that. The matter actually gets even worse because there are large companies that will use software to track their products and what have you on the internet and then issue DMCA takedown notices. And so no actual person is looking at the content in question to make a determination as to whether there's infringement. They're just basically working off of keywords, and that can lead to humorous results. So a few years ago, Microsoft's software system got a little out of whack, and they started issuing takedown notices to sites that were publishing press releases that Microsoft had issued and wanted published. A press release, the whole purpose of a press release is to get it republished everywhere and to have that content, perhaps generate articles and things of that sort from people in the journalistic field. You don't want to be taking those down. And so it was rather humorous to watch Microsoft scuttle its own press release. But even in that situation, there wasn't really any ramification other than embarrassment from taking those steps. So DMCA abuse is a big problem. And unfortunately, there's just no resolution at the moment for it. The next area we see questions about is the DMCA creates a whack-a-mole situation. Again, this is a valid criticism, and unfortunately, it's something that it's very hard to figure out how you would fix it. So, what are we talking about here? Well, let's say you create a course online. You're selling your course for $399, and one day you get an email message from somebody who says, "Hey, I found your course on another site and it's only being sold for $99. And sure enough, you go to that site and there's your course. Somebody has copied your sales page. They've copied all the content, copied the videos, whatever it is that comprises that course. And then it's being sold for less. So what can you do? Can you go after them with the DMCA takedown notice procedure? Absolutely. So you would issue DMCA takedown notices to the host for that website, potentially to the parties who are processing the payments, to Google, to or to Yahoo, to Bing, really try and hammer them from that perspective. And sure enough, one of your DMCA notices works. Let's say the host reacts and says, you're right, and they take down that content. Woohoo! You've won. Victory is yours. Or is it? Let's say another week passes and you get another email from somebody saying, hey, I wanted to buy your course. I'm seeing it on this other site. It's being sold for $99. And you go to that site and you see, yep, there's your course again being sold by somebody else. And so you file another DMCA takedown notice and it works and the site comes down, or the page comes down. And then 2 days later, you get another email from somebody notifying you of another site that has your course up, and it goes on and on and on. And the closer that you look at these sites, you start realizing these are simple templates that people are putting up on random hosts, and that this is probably the same group who owns all these different sites. And the question is, can you use the DMCA to short circuit that? Is there any way to stop that? And the answer really is no. You just have to follow the whack-a-mole approach. You could file for a copyright infringement lawsuit in federal court and try to get the court to issue subpoenas or issue court orders forcing the host for those websites to kick up the information regarding who owns them, to the extent that party knows. That may return somebody's name, but it may also just return an offshore corporation or something of that sort, which can be extremely frustrating. And so, unfortunately, again, this is another area where the DMCA kind of falls apart. But there really isn't a grand solution. I'm not sure how you would change the law to address that. The DMCA does contain a provision called the repeat infringer provision, where somebody posts, the same content on the same website. So you went to Facebook and you said, hey, somebody's published my content without permission, take it down. Facebook takes it down. And then that person publishes more of your content, again. Well, at that point, you would complain. Facebook's keeping a record of the repeat infringers, and they would eventually terminate that person's account, typically after maybe 3 offenses in 2 years. And so in that sense, it works. But when we're talking about somebody just bouncing from cheap website to cheap website, from cheap host to cheap host, yeah, it can be a real problem, unfortunately. So our last topic, last question, actually an area of questions that we get involves intellectual property. Does the DMCA apply to patents and trademarks? And the answer is no. The DMCA is a federal copyright infringement law. It's not applicable to patents and trademarks. There is no equivalent of the DMCA for patents and trademarks. So you're going to be dealing with different issues with those two areas of intellectual property. The difference between copyright and trademark can sometimes be a little difficult to understand because they tend to blend into each other. So for instance, you take a title of a book or a movie, is that something that you can copyright? And generally speaking, the answer is no, because it's not long enough. So it's not creative enough and unique enough. And you're just not going to see the Copyright Office accept filings for that, and certainly they won't be enforceable. But can you then trademark a book title? And again, there's some issues with that that can make it difficult, but you at least have some potential viability in that area. But this is the reason why, particularly with books and movies, you'll see other titles that seem shockingly close to whatever the original blockbuster piece is. So if you see the Avengers movie, Infinity War, and then you'll see, do a search for it on Netflix, let's say, and there'll be other, B-level movies that pop up, and it'll be, the Enforcers, the Perpetual War, or something of that sort. Strikingly similar, seems to have the same general plot and those kinds of things, and that's why those are sliding through the cracks in intellectual property. Unfortunately, the law can't cover all these areas. So the DMCA again just applies to copyright, does not apply to patents and trademarks. So that's it for today's questions. If you have any questions or comments about this video, feel free to contact us at dmcaagentservice.com. We'll be publishing more DMCA and copyright videos week to week, so feel free to go ahead and subscribe to our channel. And other than that, have yourself a good day, and thanks for watching.